Justice Scalia, thank you for agreeing to talk with me today about legal writing.
Glad to do it.
I wanted to ask you, first of all, why does it matter how well lawyers write?
Well, indeed, most of the communication that lawyers engage in is written. To write well is to communicate well. To write poorly is to communicate poorly. It also matters because to the extent that lawyers don't write well, to the extent they abuse words, to the extent they use them incorrectly, they are making dull the tools of their trade, which is a terrible thing. There are some things that can't be said as cogently, as concisely, and as precisely as used to be possible. For example, the word alibi, which once had a very precise meaning that lawyers understood, perhaps because lawyers understood Latin in earlier days, but its derivation is from the Latin, from there. And it was a very precise kind of an excuse, not a general word for excuse, which is what it's used as now. And that's a shame. I used to be able to say alibi, which meant a whole phrase. He was somewhere else. One of my pet peeves, what is happening recently is another word is becoming less useful than it used to be, and that is the word cite. To cite. In more and more briefs I find he cited to Marbury versus Madison. You don't cite to a case, you cite a case. And when you put in the unnecessary to, you make it impossible to use the indirect object construction, which was possible when you used the direct object. That is to say, you used to be able to say he cited Marbury to the court. You can't possibly say he cited to Marbury to the court. But it is just basically illiterate to put in the to, and it's a shame. It's dulling one of the tools of our language.
I take it you don't like extra words and sentences that don't do something.
No, when I edit drafts of my law clerks, most of my work consists not of additions, but of deletions. And when I re-edit my own work, which I do, I go over and over again. I'm usually cutting out words that, on reflection, seem to me unnecessary.
How many edits would an opinion typically go through in your chambers?
Oh my! It depends on how much time I have. Very often they're grabbing it out of my hand. If I went through it another time, I'd probably make further changes. But I must go through it at least 5 times.
What about lawyers' briefs? How could they be improved?
Well, let me say first of all how important lawyers' briefs are. One of the happiest events of my life was when I was sitting on the Court of Appeals, the D.C. Circuit. We had a lot of administrative law cases, which tended to be long cases with many briefs. And I remember one case we had involving standards for automobiles. And there were a lot of interveners and amici and whatnot, and I read brief after brief, and I was really getting pretty punchy, and I picked up this one brief. And all of a sudden, it really captured my attention. Everything was so felicitously put. It was elegant, it was crisp. You could see where the writer was going. And I said, who wrote this brief? And I turned over to the front, and it made me so happy to see that it was one of the best lawyers in Washington. And it made me very happy to know that you could tell the difference. You could really tell the difference. I am not a facile writer myself at all, and writing is very painful for me. And it's nice to know that it's worth the trouble. When you write well, you capture the attention of your audience much better than when you write poorly.
Do you think it's often true that the less facile writers, the ones who really struggle with it the most and put the most effort into it, are the best writers?
I think it's probably almost always true.
It just looks easy.
It just looks easy. Yeah. Yes, I don't believe in the facile writer. Maybe there's one or two out there, but
What are the main shortcomings of the briefs that you typically see?
prolixity, probably. There was one lawyer who used to file briefs before our court for a public interest law firm. And I would always read his brief because it would end when he had nothing more to say. And if that was halfway the number of pages he was allowed, he would still stop halfway. And that's what a good brief should be like. You don't have to use the 40 pages if that's what you're allotted. Use as much as is necessary to make your point. And the same's true for oral argument, of course. Sit down and you have nothing more to say.
Do you have the feeling that the best lawyers come in well under the page limits?
No, I don't. I think that good lawyers usually have enough to say that it takes up the time limit. But especially when you're representing an amicus, where you have just one particular issue that you're concerned about, you can afford a shorter brief. But somebody who's arguing for one of the parties wants to make every respectable point. And no non-respectable point. I mean, just drop the stuff that isn't strong enough.
Do you think that Supreme Court briefs are appreciably better than D.C. Circuit briefs?
No, I would not say that. And at least when I first came on this court, I thought just the opposite. Perhaps because the circuit bar in D.C. was a more specialized bar. There were experts in various fields of administrative law, transportation, communications, telecommunications, so forth. Whereas the Supreme Court bar is of course, very unspecialized, and ordinarily it's the lawyer who argued the case below and was lucky enough to get cert granted. It's not usual that a new lawyer is hired to argue before us.
Why does it matter how well judges write?
Well, just as the lawyer wants to make his point clear, the judge wants to make his opinion clear. And imprecision takes a terrible toll, especially if you're talking about appellate opinions, because the only important part about an appellate case is not who wins or loses. It's not affirmed or reversed. The important part is the opinion, and if you affirm or reverse for the wrong reason, you've done everything wrong. Because the reason, especially at the Supreme Court, where you only take cases where there are disagreements on the law below, if you haven't made clear what your holding is, you're causing, instead of reducing litigation, instead of making life simpler for courts and lawyers below, you've complicated it. So it's very important that judges' opinions be clear, and also important that they be short as the nature of the case allows, because the time gets billed to somebody.
Haven't Supreme Court opinions gotten progressively longer?
No, I don't think so. I think if you go back and look at the opinions of the 80s, I think they tended to be longer. That's my impression. Of course, a whole lot of them was legislative history, which I wouldn't do at all. I think they've gotten shorter.
But probably much longer than, say, beginning of the 20th century.
Oh, shorter than Holmes. Sure. But he wasn't always that clear either.
Do you think a lot of current opinions could be cut in half with a benefit?
Some. You want me to name names, do you?
No. I don't think so. In your book, A Matter of Interpretation, you talk about the difference between a strict constructionist and a textualist. What is the difference?
Well, a strict constructionist, the example I always give is, if you were a strict constructionist, you would have to say that the First Amendment does not prohibit government censorship of handwritten mail, because all it on its face protects is the freedom of speech and of the press. A handwritten letter is neither speech nor press, and therefore, but that's ridiculous. That's not what was intended. What was intended, those two principal manners of communication were stand-ins for the totality of expression, of communication. So anything that is inherently and principally communicative is surely covered by the First Amendment, whether it's Morse code or, I have held, burning a flag.
So you're not a strict constructionist?
I'm not a strict constructionist, and I think they give a bad name to all of us textualists. You shouldn't interpret it strictly, you should interpret it reasonably.
Is the term textualist the same as an originalist? Or is it possible to be a textualist but not an originalist?
Well, there are, non-originalists claim that they are textualists. They start with the text and then, ride off into the sunset. No, an originalist gives the text the meaning that it had when it was adopted, which is what we usually do with statutes, but for some reason, some people think we should not do that with a constitutional text. I find that undemocratic. The people never decided anything except what they decided when the text was adopted. And if you want to use that text to impose something else, you should go back to the people first and not have the court decide that we're now going to give it a meaning that it never bore.
Let's move from interpretation to the actual drafting of statutes. How could legislative drafting be improved?
You probably have to ask Brother Breyer about that. He's more familiar with what happens on the Hill. Some countries, I believe, have a more ordered process of drafting legislation and have a very professional drafting crew that goes over everything very carefully before it's ultimately adopted. I know we have some experts in our Congress, but I don't think they're let into the game early enough or late enough or whatever. Sometimes it's in the interest of Congress to draft poorly. You can pick out cases where it's clear that an imprecise word was used precisely so that both sides could claim victory. But we should do a better job in drafting. Of course, to the degree that the court does not give effect to precise language, but rather, use it, it's close enough, and they make it mean something that isn't really quite accurate, but they want to expand the effect of the statute. To the extent that courts play games like that, they eliminate any incentive for the Congress to be precise. If the courts are going to do with the language, whatever they like, who cares?
If you were a legislator, would you want to be reading every act itself before you voting?
I would want to. Whether that would be possible in the hectic pace of current legislation, I don't know. I mean, to remind you of remember when President Carter instructed all of his cabinet secretaries to read all regulations before they were issued, one knew that that was not going to happen. Sometimes the last-minute work done in the Congress is done in conference committee, and I would want to read it all, but I doubt. I don't know how practical a prescription that is.